The governor
Okay, guys.
relied on the
This
recommendations
is
of the
the
CDC
recording.
and
This is
state officials.
the hearing going live right
The
now.
governor's measures are aimed to
You're
slow the
hearing
spread
what
of the
is
disease.
happening
It's a
inside the
disease
courthouse
that's
right
highly
now.
contagious, easily transmissible, can be deadly, and has no known cure or vaccine yet. Clearly, the Commonwealth has a compelling interest in stemming the disease. I think, unless Your Honor wishes, I will not go through the traditional constitutional analysis, other than to say that if the court decides to depart from Jacobson, I think the court should arrive at the same end point following that traditional analysis. We have laid it out in our earlier papers, and I am happy to go through it if Your Honor wishes, but I don't.
I have your argument, and I understand your contention, which is brief, that whichever test the court follows, it's the Commonwealth, the governor's position that the governor ought to prevail here. I understand that.
Okay.
Let's give Mr. Mason a chance.
Thank you, Your Honor.
Mr. Mason?
Thank you, Your Honor. Thomas Mason again for Vincent Delay. Your Honor, Attorney Spector brought up some points that I'd like to address. She said the restaurant claim is a red herring. It clearly is not a red herring. This is a constitutional matter here, First Amendment, which is guaranteed under the First Amendment. Restaurants, the right to dine, is not guaranteed anywhere in our Constitution. Now, turning to these orders, they're not rules, they're orders, which have the force of law. She labeled them rules. The occupancy limits do not apply to restaurants. There's no hard number for restaurants. There's no social distancing other than a table being 6 feet apart from another table. So in other words, Your Honor, 10 people can sit up to 10 people now can sit at a restaurant table and partake of a meal and not worry about any 6 feet between those diners. Now, the reason I bring that up is if I go to mass or my client goes to church, the rule is 6 feet social distance, and the mask is on at all times. But if my client wanted to go across the street after mass to a restaurant, he's allowed to walk in with a mask, sit down at a table, and meet 5 people there, not knowing who they are, no distancing required at a table, sit down with the mask off, maybe for an hour or two. And they can do that every day. Church is once a week. It's 1 hour a week, Holy Mass.
But you're asking me to make some assumptions here.
I'm not making assumptions, I'm making factual statements here on the order.
Well, I mean, many people attend Mass more than once a week. But your point, if I understand it, is that these orders don't differentiate or don't suggest that, for instance, a family group that's living together at home could sit together in the same pew so long as that family group was 6 feet apart.
Sounds like he's making
another
up his
family
words.
group. Is that what you're telling me?
Correct. But what I'm saying, Your Honor, specifically is Mr. Delaney and 3 of his friends are required to sit 6 feet apart at any church service. If those Mr. Delaney and those 3 friends go across the street to a diner or a restaurant, they can sit at a table, no social distance, right next to each other, eat there for 2 hours if they want, and drink with no mask on.
But her answer to that, and she articulated it, is that you have to give the Commonwealth some leeway for differences in application on the ground, as she said. That's what she's saying. And is it a constitutional violation in seeking to prevent the spread of this virus to impose that limitation as a space limitation on people who are attending their place of worship?
It is a violation. Yes, it is.
It's not required uniformly. He's favoring, or the governor, the order is favoring a secular activity which is done daily throughout the day versus a religious activity which the obligation is 1 hour per week. That's what it's obligated. Now, daily mass for the archdiocese of Lake
Oh,
Hampton.
getting a call.
Those are usually half-hour
He's getting a
masses.
call.
But the obligation to attend mass is 1 hour per week. And I suggest to the court that people go out and dine more than 1 hour per week. The average person. Now, I want to get to the case in the county of Butler versus the governor of Pennsylvania, Thomas Wolfe. Judge Stickman in that case, the decision came down about 12 days after we were here, September 2nd.
I'm
Judge Stickman,
familiar with the case. Yes.
Yeah, you read, I took it that you did. But he differentiated, particularly on the standard of review. He held it to be an intermediate scrutiny. But he also realized that, in fact, you don't have to have a wholesale denial to go into mass. Now, Mr. Delaney, throughout his life, has partaken of the Holy Eucharist, only on his tongue. Church doesn't offer that. Right now, they don't offer that. So, when she says
Good point.
it's a limited, at best, a limited infringement, it's not. She's not in his shoes. The governor's not in his shoes. So for him, his faith is critical to him and his beliefs. Now, not everybody has the same level of faith. We know that. But the fact is, he is not able to receive the Holy Eucharist the way he's done his entire life. Now, that is not minor, that is not limited. The other,
I am limited to this joint statement of facts. I mean, is it in here in the joint statement of facts that that's the manner in which he has always celebrated Holy Communion, and now he cannot?
it's in there under the fact that the Mass is not conducted the same way. Prior to March 10th, it was never conducted this way. It was never denied.
Excuse me, I just want to be sure.
What does it have to do with it?
And you're making that explicit now with your argument.
Exactly, Your Honor.
Thank you. Right.
Thank you for the question.
Even if it is in the argument,
So,
explicit.
Your Honor,
What does it have to do with it?
the traditional analysis
Shouldn't matter.
Jacobson doesn't apply here. Jacobson was decided over 110 years ago. And the court since then, as you well know, they just developed the three traditional levels of scrutiny. And this deferential view, as Judge Stickman said, which is very instructive and persuasive, he didn't follow that view. Matter of fact, he cited Justice Alito talking about the inapplicability, so to speak, of the Jacobson deferential standard of review. In other words, I believe the quote is, if we suspend our traditional standard of review, we risk suspending our constitutional liberty. So the fact is, this is not a minor issue, which has been laid out to be here. This is a fundamental bedrock right of our country, First Amendment. Freedom of religion, I believe, is the first sentence. Congress shall make no law establishing, so on. The Founding Fathers, our history, this has been primary, as well as the political speech now. When outdoor gatherings, okay, well, now there's no limit. Let it go for church services. Your Honor, church services traditionally and forever have been conducted inside the building, not outside. So when they say, well, we made accommodations, that's not an accommodation, that's a burden. Now you have to move all the chairs out to an open field. You have to have staff do all that, so on and so forth. So that is not an accommodation. And further, you can't receive virtual Holy Communion. It's a physical impossibility. Virtual Holy Communion is the body, blood, soul, and divinity of Jesus. That is the belief of my client. And you cannot receive that through a video or a Zoom.
But she doesn't suggest that you can, at least as I understand the
His statement was,
you are absolutely right. You can't do it virtually. I'll accept that for purposes of this analysis.
The fact is, it was minimized. A limited infringement. The word was limited.
Careful.
And it's not limited.
There's a few places.
He has been substantially burdened. And the fact that, the same person can sit in a pew, have to sit 6 feet apart. And then those same two people, if they walk over to a diner or a restaurant across the street, can sit next to each other and drink and eat to the heart's content. 2 hours, 3 hours, whatever it may be, as long as they pay the bill. That's good. And it's favoring a secular activity, economics, over spiritual. Now, I understand
That's right.
government's trying to do the best it can, but the body and soul are composite. And in my client's observation, in my opinion, is clearly favor the body over the soul. And soul is inherently, it's the essence of who we are, of who one is.
Oh boy.
Your spirit, your soul, whatever you want to call it. And for that to be denied, like it's never been before, he's never had to walk up to a church door.
This will be interesting to see where this goes.
He meets the head count. He meets the limits. Now, if you go to a restaurant, there are no limits.
Well, I'm not. For one thing, I'm not sure, but I'm going to test these arguments strictly against the joint statement of facts. But my understanding is what restrictions there are vary now from place to place. For instance, there are greater restrictions in Boston and in Worcester, which at present are red zones, than there are, and I'm making this up, but I'm going to assume it, in Berkshire County. But there are, in fact, limits on occupancy of commercial establishments and limits on restaurants. Not that a restaurant can fill itself to its occupancy limit by the fire code.
No, but there's none, Your Honor, there's no specific limit on it in his order. There is with the church. Church numbers. There's no specific limit in his order. All it is 6 feet apart the tables. There's nothing in there about the patrons sitting 6 feet apart, 3 feet apart. No. But if you go to mass or you go to any service, you have to sit 6 feet apart and masked at all times. Now, communion, I can differentiate communion from eating, obviously. Communion is a process that takes maybe half a minute tops. If that, maybe 15 seconds. I never counted. I've never counted. I don't know if my client is. But the fact is, you cannot compare Holy Communion to eating a dinner or eating a meal somewhere. It's an opposite. It doesn't apply.
Well, so, except that no one suggests you can remove your mask to actually receive the elements.
No, what my point is this, Your Honor. What I'm getting at is you can sit at a table after you're done eating and drink
Sounds
with
like
that mask
arguing
on.
for the mask.
There's no limit.
I follow that. Yes.
Okay, there's no limit. There's no limit how long you can sit there and drink or eat with that mask off.
And you're contrasting that once you have received the elements in the Holy Mass and you return to your pew, you're expected to put the mask back on.
No, Your Honor. You're supposed to put the mask on right after you partake of it.
Well,
while you're taking, you put it. You don't even get back to your pew. You put it back on.
very well.
Okay, so there's a big difference there, and I don't think economics should prevail over. And I feel for the restaurants, but I don't think it should trump the First Amendment. And I think the case law, I think it's very instructive. Again, the Butler case, and I think Justice Alito's dissent in the Calvary Chapel case, they did,
All right, guys, this is going to be a long one. I'm going to clip it here, send you out another one, and then start another later. This is going to be a long cut, but hopefully you got some good information. You can see what's happening. I'll get back in there, and we'll talk to you soon.